Ready. I gotta hit the got it thing. I don't have that. Can I get started then?
Go ahead.
Okay, good morning, everybody. I'm John Jardinell. Oh, there it is. I gotta hit the okay. All right, so we're gonna record this meeting. I would urge you to stick around because I'm not gonna answer questions till the end. So jot down your questions. What we're gonna do is we're gonna have you put them in the chat. Laura and Sharon are helping us because I'm incompetent technologically, as you all know. And so we're gonna do that, and I'm John Giardinelli, I'm your association's attorney. Been working on all this post-settlement stuff for a long time now, and I've got a lot of very up-to-the-minute information for you. Bless you, we had a meeting on Tuesday. Included in that meeting was Steve Lerner, who's the attorney in charge of the legal department at the Department of Real Estate. Phil Hawkins, who is your new CEO at CAR, the attorneys for the multiple listing services in Southern California. So we've got some pretty good and then a member of the Standard Forms Committee was there too. It's about 12 of us. So I've got some up-to-date information you're gonna have to write down. Laura's probably gonna post this PowerPoint so you can download it if you'd like. It's perfectly fine. I wanna make a comment, however, that because we're recording this, we're gonna take it down in a couple of weeks. Because a lot of the information is continuing to evolve. And I'll go over all of that with you today, but you need to understand that by continually coming to these programs, we're gonna try and keep you up to date. Laura and Sharon and the board are adamant that we keep you as close to updated as we possibly can. So let's go to the first couple. Well, let's get rid of the first couple of slides. Just basically that's me. I'm cute as a button. I understand that. That's what we do as a law firm. We've been trying a lot of cases all over the country. Those are my lawyers, and what we're going to talk about today is the settlement hearing is coming up on the 26th of this month, so literally 12 days away, right? And so I want to tell you what's going on with that. I want to talk to you about the objections to the settlement that have been filed, and I'm going to tell you my prediction and what I think the judge has been saying about all this. Go to the next slide, please. I want to talk about some questions we've been getting. I was just mentioning that I've had over 1,000 questions, and obviously they fall into categories. And so I want to go over a couple of things real quickly today on open houses, unrepresented buyers, concessions versus commissions, some DRE issues. But there is an unrepresented buyer newsletter, and the link is right there. Also, if you look in the lower left-hand corner, there's a QR code. You can go into our website, and everything I've written for the board is there, right? Everything we've written on any subject, including corporations and employment law, because I'm not the only one that does law. We got a lot of people, so you can get, and we've I just wrote that unrepresented buyer newsletter, so that's a topic you can go if you want to do a deep dive on that. Next slide, please. I'm going to talk to you about mandatory agreements because as of January the 1st, it will be a violation of your license. Not just a civil code or a civil violation, but it will be a DRE regulatory and statutory violation to not have a mandatory written agreement. Okay. New forms come out second week of December. I'm going to cover the new and revised ones real quickly. Some new laws. And then I want to talk about what we're probably going to talk about next year, real briefly. What's the MLS up to? Just talk to their attorney. You are blessed with probably the finest MLS attorney in the nation to handle your MLS legal issues. What's going on with artificial intelligence? Because I'm going to guess, I wish if we were live, I would ask for a show of hands, because I'm guessing a lot of you are already using artificial intelligence in your marketing and your advertising and in some other ways. there's some legal issues there, so I'm not gonna go into it in any great depth today. We got a new sheriff in town coming in on January the 20th. Some of you are happy, some of you are sad. I don't see anybody shaving their head, so that's a good sign. But the bottom line is things are going to change dramatically regulatory wise. And we'll kind of talk about that a little bit, but probably wait until we see who his full cabinet's going to be. And then, of course, landlord tenant, you are in California, you've got a whole bunch of new landlord tenant laws. And then, of course, the one topic that comes up in almost everything we talk about, which is fair housing. So, and then I'm going to open it up for questions. So if you've got a question, put it in the Q&A, or excuse me, the chat, and I got no place to go today. So if you've got questions, I'll answer as many as I can. Sharon, you've always been a big help in that regard. And so we'll do that. So let's go into the post-settlement Sitzer status, okay? There were 8 objections filed. I'm going to go over them in a little bit of detail. NAR has got to file a response, and they haven't done it yet. But they're going to be filing a response to those 8 settlements. And I'm going to tell you what I think is going to happen. Obviously, I don't have a crystal ball, but I'm going to try and give you my best thought on it. A lot of the questions really don't affect you. A lot of the attorneys aren't happy because they're not getting as much money as they were hoping for. The pot of gold isn't going to be shared equitably, right? Some of the attorneys that actually won the case are going to get probably close to $60 million. And the other attorneys are not going to get even a pittance of that. Some are claiming that NAR still has a monopoly, but they don't. Zillow is making tremendous inroads. And so there have been some predictions that Zillow might even be the MLS of the future. I doubt it, but we'll see. So, and then that is going to have to be dealt with is that buyers are still not protected. And I'm going to do a little bit deeper dive on that as we proceed today. So let's go to the next slide, please. Okay, so some of the objections do relate to current behavior. Now, I want to say this to you, and I want you to listen to me very carefully. According to the MLS attorneys and the attorneys I've spoken to, and some of the top leaders like Linda DeStefano and Sharon and Bina and people like that, things seem to be going smoother than we anticipated, right? Agents, for the most part, are behaving themselves. The problem, and this is the problem with the lawsuit, it's the problem you will always face, is what lawyers, and you see it on the news every night, right? Some lady in Michigan has a problem with something, and that's an example that this is the problem. Well, it's not. It's some lady in Michigan that had an isolated problem with something, right? And so not everybody, realtors are not steering, but some realtors are. Right? They're trying to force their sellers to offer compensation in some manner, which is against the settlement agreement. Some realtors are misleading buyers and sellers about their services, about how much they should expect to pay. Most realtors are not, right? But you need to be careful about that because the DRE will weigh in on that. Some realtors are still claiming you better offer minimum compensation or you're not going to get any offers. Most agents are not doing that. They're making it a subject of negotiation. Most realtors, some realtors are refusing listings without offers of compensation. Most realtors are not, and that is a really stupid business plan, right? Well, I'm not going to take clients in. No, you take clients in and then you adjust your behavior to what those clients want. I'll talk about that a little bit later. We're getting a lot of open house misrepresentations. I think it was Linda that sent me something the other day, and I rely on you guys to tell me what's going on because I'm not a realtor. But Facebook things that you have to have an executed BRBC before you can walk into an open house. That's not the law. That's not the settlement. That's not the truth, right? I can walk into any open house. If Sharon Butler is having an open house, I don't need a thing. I can walk in. maybe she'll give me a balloon, maybe I get a free cookie out of the deal, but I can go in. It's only when we start negotiating that we have an issue with a written agreement, and that's between Sharon and me, right? So let's go to the next slide, please. Some of the objections were that brokers are shutting out unrepresented buyers. And I'm going to go into that a little bit because you got to be really careful about that, particularly for for fair housing purposes. But one thing that is true, in my view, and I don't know if you all agree with me, well, we can talk about it if you'd like to. We're seeing a lot of mass confusion because there's so much bad information out there. That's why I would urge you to rely on the board, rely on CAR, rely on people that really know what they're talking about to give you information, because people out there, it's that typical thing, you know, I say something that's a little bit wrong, it goes to the next person and it gets a little bit wronger, and then it goes on and on. Next thing you know, by the time it gets to you, it's just bad information, right? Get good information. I'm going to try and give you some today, but as things move along, we'll start getting a sense, and I think we already are, of, you know, how to use a mandatory representation agreement. How do we you know, deal with some of these issues from a best practices standpoint? Laura and I are going to have a meeting this afternoon to talk about some ways we might be able to help you. One of the things is coming up is that there's nothing in the settlement agreement that says, how do we track compliance? But the boards and the MLSs are going to do that, because if the boards and the MLSs don't track compliance and don't ensure compliance, then the settlement agreement doesn't apply to people that don't comply with the settlement, right? So if Jackie goes out and starts doing things that are not part of the settlement agreement, well, guess what? It's not covered by the settlement agreement. She could get sued. So you got to be careful about that. So what do I think the outcome? I believe that the judge is going to approve the settlement on the 26th, right? He's been approving all of the settlements from the brokerages. You know, the settlement carved out the big brokers, the EXPs, Compass, and those people, and they've entered into their own settlement agreements, and they've all been approved. Okay, so I believe, based on what the judge has been saying at those hearings, that with a couple of minor issues that hopefully NAR will address in their response, the settlement's going to get approved. And the reason the settlement's going to get approved is for two reasons. Number one, nobody really expects 100% compliance on day one, right? We got to get used to some of this stuff. And so the judge is a reasonable person, and he's going to, you know, probably monitor that, and maybe there'll be some, you know, reviews down the road of how's the things working out, and what are the MLS is saying, and what are the board saying. And the other problem, of course, is, yeah, $418 million, while that's a lot of money in my world, doesn't come close to covering what the alleged damages were. Heck, the one lawsuit alone was 5.4 billion. And so you multiply that times 22 other lawsuits. But what it would have been, had they not settled this case, is for NAR and for most of the associations, it would have been an extinction event, right? It would have been like the big meteor that knocked off all the dinosaurs, right? NAR doesn't have $5.4 billion or $100 billion or $200 billion. So it would have been an event that would have caused NAR to probably file bankruptcy and maybe worse, right? So I think the judge is going to approve the settlement. Prove me wrong on November 27th. You'll be getting a lot of information, including from the board, on what he did, and probably won't hear anything from him right away, but most of us at the meeting last Tuesday agreed he's already made up his mind. He knows what he's going to do. Now, the 26th is the day before the Thanksgiving weekend, so we don't expect to hear from him until the following week. But, you know, keep an eye on what's going on at the board, and Laura will keep you posted. Next slide, please. So what are the areas of common concern? And I'm going to do a lot more writing on this as we move down the line. But open houses, I want you to remember something. You represent the seller, right? If Frank Chen takes my listing, Frank Chen's not on his camera right now, so the heck with him. So Michael Chang, you're there. I can see you. You're kind of looking at the camera. So Michael, you take my listing and you decide to have an open house. Who are you representing that day? Me. You're representing the seller at the open house. You don't represent a buyer. So if I come walking in, you should ask me two questions. Number one, are you being represented by another broker? If the answer is yes, then you need to make sure that that broker is kept in the loop. So I'm going to say, yeah, I'm representing Sharon Butler, but Sharon had something she couldn't make it today. So she suggested I come out, see if the house meets with my approval, and then she'll get in touch with you. The other thing is ask them to sign a form that I'm going to put up in a short while, and that's it. Now, if they come back to you after looking at the house, want more information, I'll go over that in a minute. Don't mislead them. They don't need to sign anything. They don't need to sign anything. Most of you at your open houses have registration. I'm guessing, I'm not, like I said, I'm not a realtor, but I'm guessing that that's what you do. So don't mislead them. Let's go to there's a form, it's called the OHNA. Then there's another form called the PSRA. So let's say, for example, okay, let's go to those forms. I'll put them up, I believe, right now. Next slide, please. There. That's the open house visitor non-agency disclosure and sign-in. One page. That's it. It tells them, hey, I don't represent you. If you communicate with me, I may need to do some other things. If you tell me something, I'm not going to keep it confidential because my duty is to my seller, not to you. If you write an offer, we're going to need to get an agency disclosure form and all of that. And then if you want to be represented by the agent holding the open house, I'm going to need you to sign either a BRBC or a PSAR, and that's it. If they sign it and only one, let's say a husband and wife come in, the wife can sign it, it covers everybody, okay? And that's it. That's all you need. Now, if you want to get more information, like their email address, if they have another agent, all that, you can fill that out. But that's it. That's it. That's all you need, and you don't have to do it. It's not a mandatory form. It's just a way of documenting your file so that you have something in your file that says, I talked to these people. But don't freak out. I'm guessing people like Sharon and Linda, Bina, people that are pretty experienced, not having a lot of problems with these things. I don't know, Sharon, have you had any issues with open houses? I mean, it's not a problem. Don't make, how do I say this? We have a saying here in Tennessee, don't borrow trouble. Right? Don't make it more complicated than it needs to be. Right? It's an open house. I believe, go to the next slide, please. I believe the PS, okay. If they decide they want to write an offer with you, but they don't want to do a full-blown BRBC, this form, which is going to be updated in December, I'll go over the updates in a minute, but this form, which currently exists, is a qualified, settlement qualified written agreement that if they do hire you as a dual agent, then this is how you're going to be paid. You can use this form for up to 3 houses. And it's good for 30 days or less, okay? So this is the form you would use. If I come into Sharon's open house, no, Sharon didn't have the open house, Frank did, or somebody else did. So I can have you sign that form, and now I've qualified under the settlement agreement for a mandatory buyer agreement, and now I've become a dual agent, okay? Let's go to the next slide, please. Also, you probably, if you're going to represent, if somebody comes in and they say, I don't want to be represented, I will represent myself, get them to sign a non-agency agreement because you want something in your file that says, I'm not representing you, right? Because let's face it, right? If Jackie's the listing agent and I come in and I'm unrepresented, you're going to do more work. You're going to do more work. But you don't want to create a fiduciary relationship with with the buyer if they're not going to pay you or you're not going to be paid extra. And therefore, there's a form called the BNA, and there's one for tenants. There's also one for sellers if you're going to represent a buyer in, say, a for sale by owner situation. Also, don't forget that there's other issues. I had a call the other day. The person went to an open house. The agent was so concerned about all the settlement issues, they forgot to mention that there was a vicious dog in the backyard. And the 5-year-old was bitten severely. So let's not forget, just because you're concentrating on all this other open house stuff, you've got safety issues. You want to make sure your client puts away all their valuables and all their private documents. You want to make sure that you've taken care of how do we track people that are coming in and making sure that things don't get stolen or bit damaged and all that. And then of course making sure that the property is safe for the purpose of showing these invited guests. So let's not forget there's other issues in open houses besides just these forms. Okay, next slide, please. If you're going to represent an unrepresented buyer, talk to your seller when you take the listing, because in section 2C2 of the RLA, the listing agreement, there is a provision for them to agree to pay you a little bit of extra money. And again, I'm not going to get into how much, but you can get them to agree. If you check off that box, they're going to pay you some extra money to take on. Now that doesn't mean you're going to be a dual agent. It just means you're going to help to the extent you don't become a dual agent to that buyer, but you'll get compensated for it, right? Because you're going to do extra work, right, Sharon? I mean, if you're going to represent an unrepresented buyer who doesn't really necessarily know the system that you all are familiar with, you want to be paid. But if you're not going to get paid, you still want to use that BNA form because you still have a duty to present all offers objectively. Now, what happens if this is not in this slide because I just thought about it. So let me see, who else can I pick on? Who's here today? I could have sworn that Linda Stefano is here. Linda, are you here?
Linda's here and so is
Marion. Okay, so let's say Linda's the listing agent and you have an unrepresented buyer. Everything else is cool. You're not representing them. You can give them the form because the CAR copyright rules say you can provide forms, blank forms, to anybody that is involved in a transaction that you are involved in, right? So if Linda's the listing agent, she can provide an RPA form to the buyer who then can fill it out on their own. But what if the buyer writes up an offer and it's a sloppy offer, right? Does that mean you should just ignore it? No, what if it's a full price sloppy offer, right? It's just not an offer. What you can do there is fix it by counteroffering, right? Take your counteroffer, indicate that the offer is rejected, and then counter the offer with a corrected, full-blown RPA that has everything your seller wants, provide it to them, right? There's other ways you can fix the problem. What I see is this black and white kind of approach that a lot of agents are taking, and I don't think that's necessary. I don't know if anybody disagrees with that. I'd love to hear from Linda if she would come out of hiding, or if Marianne Prophet's here today. Sharon, you or Bina.
I'm here.
I'm here. This is Marianne.
But there's a way to again, your job at the core is to get this house sold for a purchase price your client finds is to be fair and adequate under terms that are fair and reasonable, et cetera, right? And there's only a few things that are against the law when it comes to making an offer or a counteroffer. For example, you can't put in there, if you're not Caucasian, we're not going to consider your offer. You can't do stuff like that. But you can say, look, we're not gonna take your offer, but we're gonna counter it, and here's our counter offer on the corrected form, right? Or something to that effect. What happens if they're asking for more money on the commission side than you want to offer? Do you counter that out? Or do you simply indicate, we're gonna counter the amount? We're willing to pay commission, but we're not willing to pay what you're willing or what you're asking for. Or you can simply reject it and whatever you want to do, but be
So
careful.
John,
Yeah.
this is Marion. So you're asking for us to give feedback. One thing that I think, and I do understand, nobody likes to do extra work, but we are working on behalf of the seller. So if I get let's just hypothetically go back in time prior to this whole commission issue. If I got a wonky, I mean, there are agents out there that write wonky offers that are not properly written. And that's my job for my seller to go through it point by point. I don't care if it goes into the text overflow, there's 3 pages, doesn't matter. That's my job to go through and clarify and counter each detail to make it so that it would be acceptable to the seller. And it's no different than this. It may, yes, it does require extra work potentially, but that's what we do.
It's not extra work, it's work, right? I mean,
I agree.
your job is to do whatever it takes to get that property sold within the bounds of the law and your standards of practice, ethically and otherwise.
I
right?
agree.
And
I
so
agree. And I
if
only
I
want to
thought
say some people will avoid, their tendency, of course, is to say, I want to work with somebody who's going to write me a beautiful, clean offer that, I don't have to worry about it. We just have to shift our attitudes and understand this is the new
your
now.
job
Yeah.
is to provide all offers objectively, not lazily, right? So I get an offer, you know what, these people, we're asking for, 900,000, people are offering 880 all cash. But the offer itself is not meet muster, right? It doesn't meet the level that we are used to. Then fix it. And as a counter, don't go back to them and say, let me work with you to rewrite your offer. Don't do that, because that might be over the line in terms of becoming their agent involuntarily. That's called implied agency. What you want to do is counter it, fix it, do whatever it takes within the bounds of the law, your code of ethics, because again, particularly if it's a down market, right? If you've got 75 offers on a property, well, that might be different. Okay? But anyway, enough is said about that. Laura and I are going to talk today about maybe doing some vignette kinds of thing, where we maybe do a 30-minute thing on some of these subjects and maybe do a little bit deeper dive. So again, be careful about understanding that there's a difference between providing information and providing advice, right? Your advice is your time. What did Lincoln say? It's your time and your effort, right? You don't give advice to a non-client. You don't do that. I don't do that. You don't do that. But that doesn't mean I can't say, you know what, Ms. Prophet, you can go down to the county assessor's office and they have information, or you can go to this source, or you can do that. It's just information. That's not necessarily advice. Advice would be, well, I think your offer is too little, maybe if you wanted to do this. Now you're starting to get into representation. Be careful, because you don't
Hey,
want
John, question.
Wait a minute, please. You don't want to get into a situation where you suddenly become a fiduciary, okay? I notice that we have 12 questions, so put your question in the chat, please, but if you want to go ahead and ask it now, please go ahead. But I'm going to ask that we hold off questions for later. Go ahead.
Oh,
Whoever.
thank you. I wasn't sure of that, the protocol there, but in the future I'll
No
use the
problem.
chat.
Oh, it's Paul. Never mind, Paul. You wait. No, I mean, go ahead.
Ah, thanks. Quick questions. We're talking about offers, and sometimes, I've gotten, just like Mrs. Prophet has said, I get offers from buyers that are using old contracts, from 10 years ago that are outdated. And I would counter back, and I don't know if this is, please use the updated, CAR
No, that's
form.
absolutely correct. Because
Okay.
CAR will not stand behind outdated forms. And
Okay.
that's a big issue. Again, we're talking about two different kinds of people here. If an agent isn't doing her job, tell the agent to do your job. right? Now, you might want to present the offer, but indicate that it's not going to go forward and be accepted if it's an old form, because again, they changed the forms for a purpose. But now you're dealing with another agent who's just sloppy or lazy or whatever, right? But we're talking about lay people, right? Unrepresented buyers who are truly unrepresented. Nobody's representing them. Now, what happens if it's an agent in your office? Now, that's not an unrepresented buyer. Now your broker's in a dual agency situation, and the agent in your office will have to comply with the BRBC and all that other stuff. We wrote a pretty significant newsletter, and the link to it is right there on your screen. You can also get it by going into the QR code. So keep an eye on that.
Okay.
And then, and also for some quick advice, CAR has published 2 really good quick guides on unrepresented buyers. It's called Unrepresented Buyers Part 1, and guess what? Unrepresented Buyers Part 2. It's very good. Keep it handy, put it in your file and keep it handy, because it answers some basic questions. Doesn't go into a lot of depth. Brad did a little bit better job, I thought, but Brad's article is 6 pages, not 2. So take a look at that. Linda or Laura, I believe you've got it posted to the association's website. Well, you've been gone, so maybe I haven't had a chance to do that yet, but it'll be up on the association's website shortly. Or you can go to our website. There's the link. Next slide, please. Again, real briefly, in this post-settlement world, I want you to understand that a concession is not a concession. It's not an offer of compensation, right? The buyer gets to decide what they want to do with whatever you're offering. Okay, so a concession means you guys have been doing concessions forever, right? I'm going to guess, Paul, for instance, since you're there, Paul, you've been probably writing up offers or been seeing offers where the buyer will say, we'd like you to help cover some of our closing costs, maybe I'm in a case right now for a family member, and the issue is, and it's here in Tennessee, but it's the same thing as what you guys do, right? The argument is over the credit for repairs.
Uh-huh.
Right? There are certain things that we've discovered and we want them to, fix these are things that a seller should have not put the property on the market with, didn't disclose when we found out about it. I'm helping my niece buy her first house. And so the realtor that she's using, my realtor, we're trying to get a pushback on credit, right? That's a concession. Closing costs are concessions. Pay down on rates are concessions. So the new kind of concession is commission concession. And they're thinking about changing the RLA in December. They'll know in about a week or so. Linda, I know you go to those meetings where they're talking about putting a concession field in the actual RLA. Okay, so buyer chooses how to use it. Now, when does the buyer make that decision? When he writes up the offer, right? Because you in the offer under the matrix, there is a place where you can ask for the seller to help pay down or pay all of the buyer side compensation. So you got to use the RPA correctly. First of all, if you misuse concession versus commission, you're going to get a letter from Ed and his people at the MLS, and with it's going to be please send us a check for $2,500. So make sure before you make that mistake that you read, and if you're not sure, pick up the phone and call somebody so that you don't get it wrong. The way you do it is very simple. In the RPA, under 3G, I believe it's 3, Linda, whoever, you're going to check off a box that says, we'd like you to pay X amount of dollars, and then we're going to attach a form called the SPBB. That form is going to go away in December, and in its place, all that information is actually going to be in the RPA. So come to second week in December, when you write up an offer, you won't have to write up a separate SPBB. It will be in the offer itself. Just fill it out. Now you've asked the seller that whether they've asked for I don't know about you guys, I'm not a realtor, but it seems to me, even if there's no offer of concession, or mention of concessions, I'm still writing, if my buyer finds a house that I like, right, or that she likes, I'm putting an offer together, and in the offer, I'm gonna say, she has no money, we'd like you to help pay, and maybe we'll sweeten up the purchase price, or whatever you guys do strategically, and we'd like you to pay towards her commission that she owes me. And if that's the case, then in the December form, you won't have to come up with a separate seller payment of broker, buyer broker compensation. What you're gonna do is just put it in the RPA under the matrix and we'll be done, right? And we're gonna be doing a newsletter on the new forms as soon as they're finalized, which should be in about a week or two. So keep an eye on the board's website for that. How do you counter? You counter, right? Linda, Marion, Sharon, Bina, anybody that's out there, how do you counter? Well, you either reject it, right? I get an offer and it says, I want you to pay X% or X dollars, including up to all of my seller buyer side compensation. What's my seller's response? Yes, no, or maybe, right? Sure, we'll pay it. You accept the offer. No, we won't pay it, and I'm not offering anything. It's a rejection. Or a counteroffer, we'll accept the rest of your contract, but we're countering out all or part of that compensation, right? And that's how you do that. By the way, the counteroffer form is being changed in December as well. I'll go over that later. And then the lender approaches are different, right? They have limits on what they'll allow for credits for everything but commissions. But as long as the commissions are within historically reasonable levels, whatever they consider that to be, they'll be okay. Even the Veterans Administration. And now with the new administration coming in, I suspect that all that stuff will be extended and continued. So again, if you have questions, we already have 12 questions in the chat, but I guess a lot of those had to do with the PowerPoint. All right, next slide, please. What's the DRE saying about all this? Well, we had a talk with them on Tuesday, right? You've had him as a guest on your legal panels. Sharon, I know you moderated that for us. And what are they concerned about? Lying. We call it now something fancy. We call it misrepresentation. Lying. Don't lie to your clients. If you lie to your clients, you're gonna get in trouble. Might even to the extent that you lose your license or have it suspended. Be careful of dual agency. You don't want to be a dual agent, because if you're a dual agent, you have to have two separate written agreements. You have to have a listing agreement from your seller, and you have to have a BRBC or some type of a buyer compensation agreement from your buyer, right? You have to have two agreements and two ADs, two agency disclosures, which have to be signed before they sign the listing agreement or the buyer representation agreement. Remember what your fiduciary duties are. If you're representing the seller, as I said before, in an open house situation, you don't represent the buyer. Your fiduciary duty is to your seller. But if you are representing both, you have dual fiduciary responsibilities, and they're monitoring that. Brokers, you gotta supervise. I talked to the commissioner on Tuesday. We're putting together a broker supervision class for credit, and we'll have that out very shortly. And then, of course, be careful about supervising, because one of the regulations they're probably going to be looking at as they restructure some of the regulations after the settlement is the supervisorial responsibilities of a broker. So for those of you that are your firm's brokers or training managers or compliance officers, be aware of that. And then advanced fees. Remember, advanced fees mean fees you get to put in your pocket right away. Those are pretty much against most law. So if you have an issue where you want to take a retainer or do something to be paid before the escrow closes, you need to talk to your lawyer, because you need to get permission ahead of time from the Department of Real Estate to do that. Okay, next slide, please. So we got this thing called mandatory buyer representation agreements. The settlement that NAR reached with the defendants was that as part of the settlement, any property that is listed in the multiple listing service that you are going to show, you must in advance have a buyer representation agreement. So it applies to anyone who wants to be covered by the settlement agreement. Article 3 of the Code of Ethics says that if you're a realtor, you can only gain access in a manner that the seller has advised their buyer, or has advised their broker, I should say. The settlement agreement must be reached and signed before you start touring. So Sharon, you send me a bunch of information about a bunch of houses. You have to have a buyer representation agreement for that? No. We're going to define it in the regulation. So it won't be in the settlement agreement, or in the, it might be, they might put it in the MLS rule because the MLS attorneys were there. But it's going to mean when you physically or what's the word when you go virtually enter a property. Okay? So if you're going to go with me to see property, you're touring. And if you're touring, you have to have a BRBC or some other type of a buyer representation agreement. That's going to be in the new regulation that will come out sometime early next year. Okay? So touring means physical entry. If you look at the BRBC, it defines broker involved property. Broker involved property that you went into, made an offer on, all that kind of stuff. Bottom line, before you do any of that stuff, you got to have a BRBC. So Sharon, we're going to do it virtually. I live in Tennessee. I'm moving back to California, not in 100 years, but let's play fantasy. Okay. We're going to start virtually touring properties. You have to have a BRBC for that. Simple. And if you don't, and somebody reports you, by the way, it is not your responsibility as the listing agent to make sure that the buyer and the buyer's broker have a BRBC. That is not your problem. It is an MLS rule. Report it to the MLS if you have suspicion. They're allowed to say, hey, Sharon, send me your BRBC or your buyer rep agreement. If you can't do that, you're going to get a nice letter from Ed or Jeff down at the MLS, and it's going to say, hi, Sharon, how's it going? Hey, do me a favor, because you don't have a listing agreement, you wouldn't send it to us. Send us a check for $2,500.
Ouch.
And if you don't, we're going to suspend your membership. And we're going to take all your listings out. Okay? Pretty serious, so do it. Let's have it. Now, it gets even better come January the 1st. Let's go to the next slide. On January the 1st, there's a typo. I didn't catch it. Crystal, it's all her fault because I didn't catch it. It should read 2025, obviously. On January 1st, 2025, all licensees in the state of California, not just realtors, not just members of the MLS, every licensee in the state of California, commercial, vacant land, everybody, by virtue of having a real estate license, either as a broker or as an agent salesperson, will have to have a written agreement with a buyer. The regulations are going to say before you start touring. Okay, so it applies to all properties except rentals. If I'm renting a property, I don't need a BRBC for that. Okay, it includes vacant land, commercial, residential 1 to 4, residential 5+, industrial, any property you represent a buyer in, you will have to have a written agreement, right? It even includes ground leases that have improvements. So if I'm buying your ground lease, I have to have a written agreement. It cannot be for longer than, now the statute is a little ambiguous because 3 months, well, 3 months in January is different than 3 months in February, which is different. So what the regulation is going to say is it will be 90 days commencing on the date, and I don't know if it's gonna be the date of or the date after execution. And it will go for 90 days, and it doesn't matter if the 90th day is a Saturday, a Sunday, or a holiday, it expires. Period. Period. And you cannot have it automatically renew. You have to renew it with an addendum or a new BRBC or something in writing signed before the date of expiration that it's being extended. Okay, you can't put in the body of the document, this document will automatically roll over. That's called an evergreen clause. You can't do that. Okay, you have to have it signed as soon as practicable, but no later than you have than the day you write up an offer. Sharon. So what the hell does as soon as practical mean? Here's what we're going to do. Probably now, okay, those of you that are watching this on video, you know, in the recording, I want you to hear this because I'm going to say it to these people very nicely. I don't have a clue what as soon as practicable means. It's totally ambiguous. So what we're going to do, at least as of today, it may change because he's got to go through the whole bureaucratic stuff. So we'll keep you posted. So when the regulation actually comes out, probably in sometime around late March, early April, here's what it's going to say. Sharon, we are creating a rebuttable presumption that you can have this agreement signed before you start touring. It will be your burden to establish that you couldn't do that. Otherwise, as soon as practicable means before touring. Now, we're also going to put something in there that says, it's in the statute, that if you don't have a written agreement, so let's say I hire you and you drive me around to all these houses, okay? And under the old rules, we had this thing called procuring cause, right? Where I can establish I did enough to at least earn some of the commission. No longer. If you don't have a written agreement and I say to you, you know what, I'm going to pay you 6% if you find my dream house. All verbal agreements are void and unenforceable. You don't have anything. So it's to your advantage as well as to the protection of the consumer to have that written agreement, and it's going to be your burden to establish why you couldn't do that. Maybe I'm on duty in well, we don't go to Afghanistan. I'm not available for whatever reason, right? I can't sign it, or I won't sign it, or whatever. It's going to be a pretty narrow group of reasons, right? And it's going to apply to every licensee in the state of California. So if you lose a client that you have a written agreement to with another client who's not, not willing to, or not going to not make them do that, you can report those people, and it's a violation of the Code of Ethics. It'll be a violation of the MLS rules, and it'll be a violation of the Department of Real Estate regulations as well. Okay, that's what's going to happen. Any verbal agreement will be unenforceable. Linda, this is the first time you're hearing that. What do you think?
I agree, John. I think it's going to cause some issues with agents who think they can wait till they go to write up an offer like the past was. And that's going to be a problem.
Good. Then, because I'm going on another cruise next year and I need to pay for it. So, no, the reality is, look, you're professionals. We're not going to keep this thing hidden. This isn't going to be a hide the salami kind of thing. We're going to be telling you between now and when the rules become effective. I'm going to teach this. You're going to teach this. Whoever, Sharon, I know does a lot of programs. Whoever does teaching, Laura's going to make it incumbent upon me to make sure that all of her agents know what's going on. And we're going to do that. There's this old adage, you can bring a horse to water, you can't make it drink. I disagree. If you make that horse thirsty enough, if you say to that horse, if you don't have a written agreement, you ain't getting paid. You could pay a $2,500 fine, not only that, and not get paid. You may have a DRE inquiry, which will cost you tens of thousands of dollars to defend, right? You could even lose your license if it's proven that you do it all the time, because what the DRE is gonna do is they're gonna subpoena all your records, and they're gonna find out you never asked for written agreements, that it isn't something that you did as an accident, because that'll get you a slap on the hand. But that's something that you did purposefully and as part of your business practice, and they're gonna nail you to the wall. Good.
Yeah,
Maybe you
John,
learn your lesson, because guess what? If I said to you, well, gee, I'm sorry, I didn't keep up with the law. I didn't know that the statute of limitations had run on your case while I was investigating. You think I'm gonna have a valid excuse for not, or you say, or your doctor says, well, I know there's a new procedure that could have saved your life, but geez, wasn't paying attention.
Well, what they would do, John, is they would have you for negligence. And if you go to the DRE meetings, they have a lot of people under for negligence because that's a form of fraud.
I'm gonna be speaking to all the prosecuting attorneys at the DRE. They've asked me to come and do that. I'm gonna have to wear a coat and wear shoes. You should be there to take my picture.
And a tie. I'd love to
And
come.
I'm gonna wear a tie on Tuesday. I hate that. And shoes, because I'm gonna be doing a live thing in California. But the
John?
bottom line is that I agree with Linda. We're already having problems with that lower 10%, right?
Yes.
The big offices, in my personal observation, this is not fact, this is just my observation. The bigger offices with people like Linda and Sharon and Bina, people that, make sure that compliance is being taught, they're doing fine. They started these mandatory buyer representation agreements 6 months ago. This is not an issue for them. It's the smaller offices that are kind of out there. And that's why being a member of a board like Tri-Counties is so valuable, because we make you a bigger office if you're willing to listen. Now there's 69 people here today out of what, 3,000, right? And that's the problem. People aren't keeping up, and it's not the board's fault. It's not CAR's fault. It's not NAR's fault. Yeah. Now let's go to the next slide, please.
John, this is Linda. May I make a comment? I've already heard a listing agent threatened a buyer's agent after they were already in escrow, that they looked and saw that the buyer rep agreement was signed after the showing of the property, and threatened that the seller technically really did not have to pay that particular broker.
That's going to be the kind of things that arbitrations are. I'm of the opinion that procuring cause is dead. The idea that the listing went in the MLS, the listing agent was offering X percent. Two agents think that they're entitled, and they go to the board and fight it out. I think that's dead because there's no MLS offers. So it's going to look different for disputes between buyers and sellers agents and all that. That's going to be completely different down the road. Okay, so again, you can't automatically renew under this new law. And I've got to text Crystal and tell her to fix it. You can, so Laura, we may want to get it fixed before you actually post it. You can still send information without creating an agency relationship, right? We do all the time. People, your members call me, I answer a quick question. We don't have an attorney-client relationship. Now, the contract, and this is important, the buyer representation agreement must define the compensation to be paid, must define the services to be offered, must define when the compensation is due, and when termination occurs. The reason I recommend to people that they use the CAR form as opposed to some of these other forms is CAR is guaranteeing compliance, right? And some of these other forms that I've seen may or may not completely comply with the new statute. So be aware of that. All right, next slide. How are we doing on time here? Woo! We're halfway through. New forms. Oh, let me get out my new forms thing. So we got some bunch of new forms coming out. I want you, what's the status? Listen to me. Look up. Hear me. They don't come out till December. So all the forms you're currently using are still good. None of these forms are available. Period. End of story. Okay? In about a week or two, they've had their final meetings. There's still a couple of things they're working on. There will be redlined versions and or examples of all the new and revised forms. there'll be, the forms, the new ones will be out for your review and teaching, although they won't be available for probably the second week of December. But the forms that are being revised will be in red line format, so you can actually see the changes I'm gonna mention right now. So what do we got for new forms? Got a couple. We have a thing called the buyer confirmation of compensation. And it is a form that will provide some additional proof. It's not a mandatory form of what your compensation is going to be. It's a pretty good form. It provides evidence of what the buyer's willing to pay and what is agreed to pay, so that if we get down the line and there's a dispute, you have another little piece of evidence to make your case. There is a cancellation of agency. Let's say, for example, Frank, you've shown me, Frank's looking down. Sharon, we'll pick on you. Sharon, you show me 8 properties, okay? And we make an offer on one, and for whatever reason, I don't have the money to pay you, okay? And there's really no reasonable way I can do that. This form will allow you to cancel the agency, period, okay? So it's like I said, when the form comes out in its final form, I'm reluctant to put it up now because they may make some more changes. We're gonna do a newsletter. We'll get it out before the December release. So take a look at the newsletter and it'll cover a lot of that stuff. There are 2 forms coming out, one for the buyer, one for the seller. It's called estimated compensation cost for the buyer. It's kind of like in addition to your net sheet, right? It'll give you the ability to fill out some information on what your estimated costs will be based on purchase price and some other facts. So I will have that information so that we can have a legitimate conversation about how I'm going to get paid if the seller isn't willing to step up to the plate. But it will allow, so that's a form that comes out. Now, I just had this case. I wish I would have had this form. Agent works for broker number 1. We have a buyer representation agreement with the buyer, which is actually an agreement with the brokerage, not with the agent. The agent is now going to transfer the buyer representation to another office, and the buyer wants to transfer the agreement or the escrow, whatever the status is. There will be a form coming out in December that will cover that. It'll have things like, okay, Sharon, I'm working for you, right? And so whatever I'm doing for you, you're liable for under California laws, potentially for my negligence or other things. It will cut off the liability and transfer all liability to the new broker. Wait a minute, Sharon has spent money to promote things, to train that buyer's agent. Sharon wants a referral fee. It has a provision for that. So all of the things that will come up in the way, as long as the 2 brokers remember that it's about protecting the client's best interest, all of that can be laid out in this new TOBR form, which comes out second week of December. Next slide, please. Obviously, because there's some changes to agency disclosure law, such as you have to have a written agreement, the AD form itself is changing to come up, to comply with the buyer representation agreements and the changes that need to be made to comply with all the new laws. I love this new change. I have this question come up all the time. If you look at this is not a settlement related form, but I love it, so I put it up. Somebody write, Tess, you're up there. Oh, no, you're gone. God, people just put their cameras on and then they go away. So Sharon, you seem to be paying attention. So Linda, I'm going to pick on you. So you write up an offer and send it to Sharon. The offer says that it's going to be good for 72 hours or, and then if you don't fill that in, but whatever it is, that offer technically expires. And I get calls all the time because 3 days isn't necessarily enough. Maybe you're gonna go, and not respond. Maybe people are not gonna get back to you. But all of a sudden now it's the 4th day. Technically, there is no offer on the table, but now they respond. Right? And so they're gonna be changing all the counteroffer forms to say, and we agree that the offer didn't expire. Okay, it's just to clean it up and make it clear that I am responding and I consider the offer still to be valid. Okay, and as long as everybody moves forward, solves the problem. I love it. They're going to modify, there's a form called the Buyer Financial and Personal Information Form. I really like it because it talks about things like, I'm pre-qualified, I have this thing and all the financial information. And also that this is where I'm getting the money to pay Sharon, okay? They're gonna revise that a little bit to make it absolutely clear that Sharon, the information I'm providing you is confidential. And unless I give you written permission, you are not to share that confidential financial information with anyone else, okay? So they're gonna clean that up a little bit. Then there's a cancellation of buyer representation, right? I can't work with you anymore. Pamela, I don't have the money to pay you. Sorry, I lied, right? But now you're a fiduciary. You want it in writing. I'm not representing you anymore. But what happens if there's like 6 or 7 properties involved, right? And this one particular property is not offering compensation, but maybe the others will be. You can cancel as to one property, but not your entire BRBC. Or you can just cancel the agency in its entirety. It's just written, they're gonna clean that up a little bit because there's it's available today, but they're gonna clean that up just a little bit. Because here's the problem that right now it says 30 days, but what if you wanna cancel sooner? Right? So they're gonna add a paragraph where it says 30 days and you can put a shorter period of time in there if you choose to do that. Next slide, please. They're gonna clean up the PSRA that I showed you a little while ago. And let me tell you how they're going to do that. They're gonna allow for, remember the statute is gonna say 90 days, but the PSAR says 30 days. So they're gonna be able to put in a continuation up to the 90th day, right? So you can extend that a little bit. And they're gonna also put in some compliance and confirm that they're gonna bundle the AD form with the PSAR, because technically, if I'm even representing you on 3 properties or even the one where I'm holding an open house, I still need a form. So I still need an AD form, so they're gonna provide that. Property visit and open house, they're gonna make some cleanup on that. Again, just to make it clear, this is not a representation agreement. It's simply you're visiting in this open house and we're not creating any kind of relationship. I'm not providing you with any information that I can't use. And what they're doing, so you understand, is the directors of CAR made a decision a couple of meetings ago. Sharon, you probably voted on this, that all of the forms would be updated no later than every 4 years or be sunsetted. And so this form is older, and so they're updating it to comply with all the new laws, and then it'll be able to go into the library as a recently updated form. Residential listing agreement. Again, they're gonna modify it to make a little clearer on the concession issue. So you'll be able to have that conversation with your seller. But again, a legitimate, non-threatening, non-misleading conversation with the seller saying, are you willing to offer compensation so I can put it in the MLS? If not, fine. But again, you want to make sure that they understand, just because you're not offering it doesn't mean we're not going to be asked for it. If this property sits on the market for what you guys consider to be a long period of time, right? Then obviously, if I've got a property on the market, the longer the days are on market, the better off the buyer is gonna be to say, well, wait a minute, property's been on the market for 70 days. You haven't got any nibbles yet. Clearly, whatever you're marketing is not getting any airplay. Therefore, we're gonna have to sweeten up the pie a little bit. By the way, just as an aside, you've probably been reading that there's a big argument about whether to do away with the whole clear cooperation, and that's the primary argument. That if I have to put in the MLS, my days on market are running, and that isn't necessarily the benefit of the seller. Then, of course, as I've mentioned, they're making some changes to the residential listing agreement, and the primary change is going to be that they're going to include in the body of the RPA the information that is currently available on the SPBB, and then they're going to sunset the SPBB. So Pamela, you came on camera, so now I'm picking on you. So you're gonna write up an offer for me, and right now, if I want you to ask the seller to pay some of your buyer side compensation up to including all of it, you would fill out a separate form. That form is going away and it'll be in the body of the offer itself, which to me makes perfect sense. I don't know, Linda, if you agree with that, because I know you're on that committee. I think it makes perfect sense.
Yes,
The
perfect.
more forms we can do away with, the better. Yeah, does it make the RPA a little bit longer? Yeah. But my standard purchase agreement is 42 pages long. Yours is 17. So 18 pages is nothing, right? So,
John,
yeah.
on that issue, right now it's causing confusion because the SPBB is the only thing perhaps the seller may want to counter with the buyer. And how do you do that? Do you counter the SPBB? Do you have them change it? There's confusion
Well,
where
that goes
if
way
it's,
on this.
if it's
on the
part of the
second-
contract, you just counter it.
It's a great change. And frankly, it came about, as I understand it, Linda, because people like you were telling people at CAR, hey, and we had your new CAR CEO on our defense attorney meeting the other day. Remember, I don't sue realtors, I only defend them. I'm one of the good guys, right? And we're trying to open up the lines of communication. So when we hear things from our membership, we can get that information in a much more efficient manner to the standard forms people, because they tend to listen more to realtors. But we know our stuff pretty well for the most part, and we hear from a lot more people, frankly. So we're hoping to open up that line of communication fairly soon. Next slide, please. So I put up the draft, but I want you to understand that that this is actually the current version. So where all this is going to be is in section G, which I don't know if we even put up. I think I might have made a mistake there. Go to the next slide, please. Oh, I screwed it up. Okay. So anyway, it's going to be in section G, and it's going to be, it's going to change that whole matrix area so that Bina, when you write up an offer for a buyer, on the body of the contract, you'll be able to say, we would like you to pay X% or all of the commission. And then the only thing you need to attach to this would be page 5 of your BRBC, which is the page that re-establishes that I've offered you X% or X dollar figure. Okay. So now you send that over to Pamela. She now has an offer with proof that I've agreed to pay you, pick a number, it doesn't matter, 2% of the purchase price. Now she can go to her seller and say, well, they want you to pay 2% out of your proceeds to Bina to cover her commission. Now you can decide, well, you know what, I'm going to net enough to make it worthwhile. Maybe we counter at a little higher price to cover that, whatever you guys decide is appropriate, right? And that's where your professionalism, that's where I stop as a lawyer and you take over as the profession, right? Next slide, please. new laws. I've already covered the most important. And what we're gonna do for you, and Brad has already done the first draft, I just haven't had time to look at it, is we're gonna do a news alert. Because it sounds so cool, right? Because we're self-important people. We're gonna do a special newsletter on just AB 2992, the mandatory purchase, the mandatory buyer representation. It's gonna cover everything that the statute covers. It's gonna talk about the regs, it's gonna talk about all that stuff. So you'll have it, and then you can start, for those of you that are brokers, you can start training your people, because even though the regs won't come out until March, the statute goes into effect on January the 1st, okay? Where am I at time-wise? I got a little bit of time. So let's cover some new laws that aren't as important. Okay, and again, I just edited, sent it over today. So I'm guessing sometime next week, you will have a newsletter on all the new laws that we think are important. There were somewhere in the neighborhood of 3,000 new laws that were presented to the legislature this year. And there were 900 laws that were signed into law. Not all of them affect you. We're not covering all of them. CAR has a new law summary. It's about 20 some odd pages long, has all the new real estate related laws. Good news is you guys did pretty well last week at the election booth. You were able to beat back the local rent control law. You were able to beat back some pretty onerous laws, and frankly, make it a crime to steal again. I thought that was pretty cool. We don't have that problem here in Tennessee. We all carry guns. So I think you got a very active legislature. They weren't as active this year as they were in the past. But then this year was an election year, next year's not. So expect a lot of this stuff to come back. That's why, and this is my opinion, I'm saying this, Laura didn't ask me to say it, Sharon didn't ask me to say it. When you guys write that check for your political action, that's where this money goes. What's that old adage, does a tree fall if you can't hear it, right? The fact is that what your lobbyists do, you hear about some of it, but what you don't hear about is all the stuff that they beat back, that they didn't get past, that died in committee, that died on the floor, that died because, or that maybe it didn't die, but they scraped most of the barnacles off of it, right? Because a lot of your elections in California, the Republicans have no say, but there's a lot of Democrats in that 50.5% group, right, that barely squeak by. You guys are still counting some of those ballots, right? And they understand that if the population doesn't like what they do, as Democrats, they may not get reelected. And let's face it, that's every politician's dream, is to get reelected, right? And so when you pay that money, you enable your unbelievably talented government affairs people, both at the local and the state level, to do the things they need to do, both locally and at the state level. I'm going to get off my soapbox now, but I wish I could spend some time, probably would be inappropriate, but I wish I could spend some time convincing you to write bigger checks. Because it's your profession. Have I said enough? Probably I have. Okay. So now there are some new laws that have been written. This one doesn't go into effect for over a year, but it'll extend the balcony inspections that are currently law. So if you've got a listing with a balcony and it meets the criteria of the statute, and the newsletter goes into pretty good detail of what that is, you got to get it inspected. And there's a special exemption and a special requirement for homeowners associations and condos and things like that. To do that inspection, you can now use a civil engineer along with the other people that this statute allowed, and that does go into effect on January the 1st of 2025. Next slide, please. I like this. So right now, Pamela, you use a handyman for any purposes in any of your transactions? $500, right? Going to go up to 1,000. So on January the 1st, you can use a handyman for up to $1,000, including materials. Okay, so that helps out a little bit, keeps some of the cost down. And then there is a new law that expands discrimination to include certain characteristics of the culture, class, race. It specifically deals with dreadlocks. It specifically deals with weaves, right? I guess you guys have to have that because I don't know why. But it does affect fair housing, so you need to know about it. And it's covered in the newsletter that I just finished it today. I take full credit for the newsletter, but another attorney by the name of Brad writes it, and then I edit it. And we're gonna do a couple more before the end of the year, but we're gonna release this one next week. We're gonna do one on AB 2992 as a special newsletter, and then of course the forms before they come out in early December, and then we're gonna do a year in review before January 1st. You know, kind of what the hell happened this year, right? And by November 26th, we'll know that the judge settled or, you know, approved the settlement. Next slide, please. So what are we going to talk about next year? Hell, I don't know. But I got a pretty good guess. We got a new sheriff in town. It's going to make a lot of changes. Some you may like, some you may not. Doesn't matter. He's right now he's working on his cabinet. I'm guessing they're writing up a whole lot of new executive orders to do what they believe the damage was that the Biden executive orders did. Things like, you know, student loans and energy issues and the border and all that stuff. So that new administration will be in charge of all of the departments within the executive branch, including two that affect us on a regular basis, the Department of Justice and the Federal Trade Commission. Additionally, they'll have tremendous authority over Fannie Mae, Freddie Mac, VA, all of that kind of stuff. So we don't know what they're going to do. We know what he says they're going to do. We know he's got both branches of Congress now, but they're not what you would call super majorities by any stretch. I think he's going to have 3 extra senators, and we don't know yet how many extra members of the House of Representatives. So it's not like he's got you know, an overwhelming majority in either house. So he's going to have to be real careful. But we'll probably see a lot of regulatory adjustments, and we'll probably see a whole bunch right after January the 20th when he takes office. Okay. The multiple listing service coming out with a lot of cool products that you'll be hearing about. So you need to pay attention to that. New rules, clear cooperation is the next big battleground. The idea that you have to put a listing in within 1 day unless it meets certain exemptions. That's going to be a big fight next year. I love this one new product. So who else can? Bina, hi Bina, my new boss. Starting on January 1st. So Bina, President-elect Bina.
Yes, Mr. Giardinelli.
How are you, young lady?
I'm doing very well, thank you. And you?
Can't complain, nobody will listen anyway. So here's the thing. You put in a lot of hours to close a buyer side transaction, correct?
Mm-hmm.
Buyers don't know that. I look at you as a buyer's agent, and if I'm a layperson, I think, oh man, I think that they did a survey, and it was something like most buyers think you put in somewhere between 10, correct me if I'm wrong, Linda, because I think you've seen this study as well, 10 to 15 hours, right? You put in 10 to 15 hours to close a deal. I'm guessing it's probably closer to 40 or 50, right? There's going to be a new product that will allow you to track that so your client will actually get correct information about how hard you've worked for them. And I think that's important. I bill by the hour, so my clients literally get an hour by hour breakdown at the end of the month of what I've done, and we do it in 6-minute increments, right? So the client can't complain, they don't know what I did. If they have a question about something, they can call the office or me, and I can explain it if it's not clear. You guys don't do that. And as a result, I'm thinking Pamela's really not that, doesn't do that much. She put a sign up, or she, drove me around a little bit, and we found a house. Maybe we found it online. Maybe I found it while I was driving around the neighborhood I liked. Pam really didn't do very much. And my goodness, she's getting a check for $35,000 for doing not much. But in reality, you don't tell them, and they don't see how much work you actually did to make that deal happen, particularly if it's a difficult buyer, right? So I like that form. Artificial intelligence. I wish I could see everybody. I wish I could ask how many of you are currently using in any form any artificial intelligence as part of your business practice. Pamela, you raise your hands, okay? So I'm going to pick on you. That was really a foolish thing to do. Anthony, you too, and Sharon, how silly of you. Okay, mostly for marketing or to use it for other purposes? Pamela, unmute yourself.
Pretty much everything. If I want to write a text, letter, whatever.
Okay, we did a hypothetical at NAR's professional standards meeting. And the hypothetical had an agent, we'll call her Pamela Briggs, who got a listing, put together a marketing campaign for her client, which included brochures, things of the things that y'all do, okay? And she had ChatGPT do a lot of them. There was inaccuracies in the ChatGPT stuff. It all went out. A complaint gets filed against Pamela Briggs, this fictional Pamela Briggs, that says that she violated the Code of Ethics, Article 12, maybe Article 11, the competency article, maybe even 2, which is misrepresentation. Okay? Who's responsible for checking the accuracy of your artificial intelligence? Is it exactly? And so what I'm going to do once we get past all this settlement stuff, as you can imagine, it's pretty much taken over a lot of our lives. I know, Sharon, you're probably pretty sick about hearing about the settlement and being on all the leadership. But next year, there's going to be other stuff. And I know the board last year, we had a speaker come in, really brilliant guy, talking about, it was what, 350,000 applications. I had dinner with my son, my wife's birthday, so we all went out to dinner last night. My son-in-law had been working for Google for a very long time, just got headhunted, and he's working on artificial intelligence for the new company. That's just, it's a, and they're doing some stuff for the music industry because we're here in Nashville. And it's amazing. It's amazing. There have been lawyers that have been cited for doing artificial intelligence, using that to write their briefs, and then the citations were incorrect. What about privacy? What about confidentiality? Who's responsible if the artificial intelligence app uses copyrightable or trademarked material, right? What are all the legal significant issues that relate to artificial intelligence? That's for next year. I was telling Sharon before we came live, I've got about 1,000, 1,500 questions over the course of the last couple of months in the programs I've done, or the clients that I've talked to, or the brokerages that I represent. And yes, I represent brokerages for anybody looking for a lawyer. I have them, and they're all over the map. So I'm going to bring them in Tuesday when I come into California, and I'm going to give them to my paralegal assistant, Crystal, the one who doesn't type very well. And she's brilliant, absolutely the best paralegal I've ever had. And she's going to give it to the artificial intelligence people, and they're going to take all those questions and they're going to categorize them for me. So that I can, when I sit down with Laura and we decide how we want to get information out to you, I will literally have questions in categories, all those questions that have come up about open houses. I think that's absolutely phenomenal. So, and then, again, we have the post, I probably duplicated this, the post-election regulatory era. Landlord tenant, and I've literally stopped doing property management work, turned it over to another lawyer in the office, because I can't keep up. Because of all the settlement stuff, I've had to kind of decide, maybe some other people are better at some other things, so. But you guys continue to expand landlord tenant. Thank God you beat back Proposition 33. It would have created such a nightmare for all of you. It's bad enough as it is with all the local ordinances, but this would have been even worse. And then fair housing continues to be an ongoing issue. We were talking to some people recently, and they were saying this, oh, it was in one of the objections, I'm sorry. I apologize, that was a misstatement. In one of the objections, they raised the issue that while, the settlement may be good, may be bad, may be indifferent, it is having a very negative effect, first-time homebuyers and minorities. Why? Because they don't have any money, right? I have my son here, he's on an airplane right now heading back to California. And he was saying, they're trying to buy another house and, with the down payment, closing costs and all the other stuff, they're not necessarily gonna have money to hire a buyer's agent. So they're gonna have to rely on the seller being willing to do that. Well, what about all these first-time home buyers that have been saving up, and you guys are better able to discuss that than I am, because I don't deal with them, right? But they're trying to find enough money for down payments, for closing costs, particularly with housing being as expensive as it is in California, right? What is it like now? The median price is somewhere around $800,000 for a house. My goodness gracious, I don't know what it is in your area, but I'm guessing it's probably fairly close to that, 700,000-800,000, maybe more, right? Show you the difference. My niece is buying a house on a half acre, 1,300 square foot house, very nice, cute little house, $320,000. What can you buy in California for $320,000? An ADU or a timeshare? Anyway, so California, you guys keep expanding costs and it's just crazy. All right, question and answer time.
Okay, so
So-
the first question that came out was back in the beginning of class. I think you already answered it, but let's just throw it out there. The listing agent, so it says, the listing agent can provide necessary CAR forms to the unrepresented buyer, as mentioned in previous webinars. Is this still in place? Can we still do that?
If you're involved in the transaction, and clearly as the listing agent, you would be, you can provide any forms. You can say to them, here's a blank RPA, whatever addendums you think they might need to see. You could, and it's not a violation of the copyright law because you're involved in the transaction, so you could do that.
Great. And we don't have a lot of questions because Linda helped out and answered one of the questions, which was great for Paul. So that
Well,
was
since
in the
I'm the
chat.
lawyer and I'm being paid, let me have the question too. So,
Do you want to see what it said? It said, I have a buyer's
although Linda
agent.
probably should have gone to law school, but that's a whole nother subject.
Yeah, she's great. I have a buyer agent showing one of my listings today. Should I be asking for proof of BRBC?
Again, no, it's not your job. Now, they may change that down the road. I don't know. And clearly, if it's obvious to you, you may want to report it and let the MLS police take over. But it is not a duty that has yet been imposed on any real estate professional on the list side to make sure that there's a BRB. Why do you need to know that, right? If they don't have a written agreement, they may not get paid. And if they get paid, they have 4 years to be sued in small claims or in real court. So that's the buyer's agent's problem. I will tell you, I spoke with Ed Zorn, your attorney. There have been very few of the 50,000 or so listings that have come through since August. There have only been about 50 or 60 violations. You guys are doing a good job on the list side. What I've been hearing on the buy side is not quite the same, but it's mostly confusion. Question like that to me says there's confusion. That agent isn't a bad agent. That agent is probably a wonderful agent, but he or she probably got information that simply is not accurate. There is no duty for you to be the MLS police.
Well, thank goodness that we're a
Trust
great
me,
association.
you can trust me. I'm a lawyer. I'm Italian. I used to be an elected official, so you know I'm truthful.
Well, I think that Tri-Counties and yourself have been doing such a great job that we have hardly any questions. I don't know if you have any additional questions, because we have one question from Marion that says, so for lawyers, if you use AI, how does it affect your billable hours?
Absolutely. That is a question I posed to the firm. We had a meeting recently about, because we have AI is now part of our library program, which is mostly online, but now they've included AI. And I think that's my niece just got her, or my niece, my granddaughter, my adopted granddaughter just got her, I call her adopted because she's really not blood, but I've known her since before she was born, right? And so now she's just got her passed her bar exam and has become a lawyer. She wrote a law review article on the use of AI, which got her a job with a prestigious law firm in Houston. So what's the question? Well, it comes up in all areas where people that bill for their time to write up a contract, right? And she showed me, because I had never seen ChatGPT, this was back last year. And she said, well, let's put together a contract. And so on her phone, she did a ChatGPT, and I saw how it was done. I thought, okay, well, it would have taken me about 3 hours to do that, right? And so it's going to have all sorts of implications to ethical billing. It's going to have all sorts of, what about the CAR forms? At what point will somebody get smart and start supplementing the CAR forms with artificial intelligence? What about auto-populating through artificial intelligence? Remember, and I made this comment at dinner last night, because like I said, we had the whole family for dinner last night. They all make more money than me, but somehow I picked up the tab. Don't ask me how that happened. But I guess because I have a daughter, right? But I asked, I said, so the way I'm looking at it is that currently we have artificial intelligence, and but it's still human centered, right? The artificial intelligence can do a much better job of sifting through all of what they need to sift through, and then creating what it believes to be the appropriate response. But we haven't got to the point yet where artificial intelligence can duplicate itself. And you know, and I know, right? I mean, I'm older than all of you. And when I was in law school, they made this big announcement that the library was building a room to put a computer in that would do some of our research for us. The room had to be air conditioned. The room had to have and you had to make an appointment to use that. This device has more, you can't see it on, this phone has more power than that whole room. And that's simply the digital era. What happens when we get to the real artificial intelligence era, right? Right now, there's about 400,000 artificial intelligence applications out there. There's going to be, and that's going to multiply on itself, right? What are the?
Okay, we have a question.
So right now, Sharon, so you were getting ready to interrupt me. I could not be a realtor. You're a realtor, right? And the reason you are is because you're capable of navigating a very complicated website called the multiple listing service, right? You can do all these searches, you know how to do all that stuff. And it's been held pretty clearly that to be considered a competent realtor, you must be able to reasonably be able to navigate or have access to somebody who can reasonably navigate the multiple listing service and other forms of technology. Anybody disagree with that? When do we get to the point where you have to be competent enough to navigate artificial intelligence? Right, Pamela's already using it, hopefully properly. I know we had a breakout session at one of the retreats I went to where this issue came up. And so being the lawyer at the table, and I don't use it because I don't advertise, I was asking them questions and I was not happy with some of the answers I was getting, right? And so that's going to be something for conversation, I think, for next year, is that, you know, where are we going with this? I think, you know, when I talk to Laura later this afternoon about Education 2025, I know I'm going to recommend that we bring in some people that are, you know, maybe these legal panels that we do and bring in, you know, everything's been geared to the settlement, which makes perfect sense. But maybe we start thinking about maybe bringing in an artificial intelligence lawyer, a cyber lawyer. Maybe I'll call Emma in Texas and see if she wants to join us, because she's working in it's called the Cyber Group. And that's what all they do is cyber law. Anybody else? Any other questions?
Okay, we have two. We have one in the chat and we have Linda with her hand up. So we'll take the chat. It's kind of written not very clearly, so I'm going to try to see what we can say. It says on the BRBC, also it needs to have the addresses. If by viewing without making an offer yet, shall we put each single address in?
Here's how you, first of all, in the BRBC, you're gonna do that if I've already seen a piece of property I like, I'm gonna hire you to represent it, okay? So we can put in specific addresses because I already know what I want to look at. But oftentimes, don't you guys, you know, I go to Linda and I'll say, hey, Linda, I'm interested in Walnut Creek or this place or whatever you guys call those cities, Chino Hill, wherever. Or I'm interested in certain regions, maybe Southwest Riverside County, which is a defined region of 9 cities, okay? What you don't want to do is put in California, right? Now, or Southern Cal, don't do that because the contract won't be valid. Now, what you really want to do is there's a form called broker involved properties. And if the relationship, maybe the BRBC terminates or you agree to go your separate ways, but you've shown, as that term is defined in the BRBC, you've shown that property, right? Marianne has gone in, given me all sorts of advice. She's involved to the extent that she would qualify for a commission if the contract was still in place. So what you want to do is within 5 days of the termination, whatever that looks like, go back to your records, however you've kept track. Okay, Hilda, let's say, for example, you have a file on me and every time you go out, you put the MLS data sheet or you keep a list, however you do it, you fill out that form and within 5 days of the termination, you give me that form and you send a copy if you know who the other broker is, right? I'm leaving Pamela to go to Sharon. Send Sharon the list and say, these are the properties I will claim a commission on. And I think Linda and her people, when we get to hearings, that's going to be an important piece of evidence when they start arguing about commissions.
Right.
So that's how
All
you
right. So Linda had a question. She has
Go ahead.
last one.
Hey, John, my question is regarding, I know January 2026 is when the balcony inspections will go into, it says except condos, and that's what we're dealing with. A lot of my agents have listed condos. They do have wooden balconies, or even if it's a stucco balcony, it's based with wood. Who's going to be responsible to get those inspections, pay for them? And is the association going to do these inspections and then the seller has to buy that report from the associations? Do you know how this is going to work?
I haven't had a case. I had one case. My client, who's a realtor, got elected to a board and they had all kinds of problems with the balconies. And I told her, resign, get off of that board. You don't want to be on that board. But in terms of that, just listening to the questions, and I don't have a clear answer, so that's my fallback position.
Okay.
I don't know if associations, first of all, if associations do the inspection association-wide, are they going to be given permission to hand that out? Because again, that'll be up to the inspectors to who's he inspecting for and who's going to rely on that and what's the liability for that. Technically, it's the seller who's responsible, but we all know that if you don't provide the adequate information or, you know, the buyer's agent doesn't make sure that because, you know, they're changing the TDSs and the SPQs and all that to deal with that, then it's going to be, you know, potentially your burden. So,
yeah, and I heard one case, it was $1,000 for the seller to pay for an inspection of the balcony.
I don't know what it costs, but I'm guessing it's probably pretty severe. Now, not every balcony, remember the balcony has to be more than 6 feet off the ground. It has to be certain material and all that. Again, now that we're getting past all this settlement stuff, I got to be honest, you can't, thank God you can't see my whole office. I got piles everywhere of stuff I've got to get to, but it's been all encompassing, you know, and I thank God I have a boss like Sharon and Laura and Beenan to, you know, to give me a little grace, because there's a lot of things we haven't been able to get to. And now we're
So-
start getting to that stuff again. And
Yeah,
read,
if you hear,
read the newsletter that Brad wrote. He did a pretty good job of doing a little
Right.
deeper dive.
will do. Thank you.
Marion has a question and we are going to be starting to wrap up. I just want to let you know that.
Thank
So
you.
I
I
got
just-
two.
I just wanted to answer Linda, or give you some updates on that. So, the place in Tahoe, because of the timing and everything on it, they had already started their inspections. In fact, they're now complete. The HOA was responsible because those were considered to be on the outside, so they were responsible. So it may or may not, depending upon the CCNRs, be the seller's responsibility or the HOA's. So just to let you know. Okay, thank you.
Thank you.
I'm a member of a board here in Nashville, one of the condos that I own, and we have balconies, and if it were a law in Tennessee, we don't have any laws in Tennessee, so, but if it were a law in Tennessee, I probably would sit down and try and figure out with our association attorney what needed to be done, because at the end of the day, you want to comply, you don't want a bunch of claims, you don't want realtors who aren't willing to work with you, you know, to get these properties sold, because that affects value. You know, it's gonna have to be a group, and the problem is that when things have been allowed to go to seed, like a lot of these associations where they don't have reserves, they haven't been keeping up, you know, it's gonna be a real problem. And then you get into the questions of, well, the association says everything is not up to speed. Who makes that disclosure and what impact does that have? And, you know, am I willing to buy the property knowing that the balcony is not properly inspected? And the legislature doesn't think these things through, and they don't provide much guidance. They just write laws that, you know, again, there's an article I have about how the laws all, you know, where they all came from. There were thousands. I mean, you can't do thousands of laws every year. Makes no sense, right? Anyway, it's going to be I haven't seen any. I saw one case, but it was not. The balconies were in terrible shape. The HOA had no reserves, and my client got elected to the board, and I told her, get the hell out. I will always tell realtors, and I hate to say this, but I always tell my realtor clients, don't run, because realtors are the best people to be on those boards, right? They have great insight into a lot of different issues, particularly keeping market value up, which is one of the things boards of directors want to do. But now if you have information that's confidential in nature, how do you disclose that if you're representing a buyer or a seller? Right? If I've seen, you know, so I hate to say it because it's not very patriotic, you know, but don't run for your board. I'm on 2, but then I'm a lawyer, so I don't care. I got everything protected.
Well,
No.
we don't have any more. Wait, I'm seeing something down there.
You're on the Architectural Control Committee, Marion. That's not a bad point. You can still serve. But again, you got to be really cautious, because if you're aware of information like, you know, wholesale violations of architectural rules or things of that nature, remember, you have a duty to disclose all material information to your clients. It's much worse if you're representing the buyer, right? Because the seller lives there and they have access to almost all the information you have. But what about executive material? Anything else, my friend?
No other questions unless somebody throws one in there real quick or puts their hand up. It looks like you've made it under your time.
I just I want to say something. So we recorded today. I'll send it out as an email next week, and then it'll be up on our website for a few weeks. And I'll take it down once the information becomes
I think
stagnant.
by the 26th, once the settlement is, because then we'll know for sure, and that affects that whole section. Also, when Steve tells me that he's forwarded the regulation on to his massive bureaucracy for comment, we'll know what, at least what the proposed DRE regulation is, and then I'll report to Laura, who will report to the appropriate. So keep an eye on stuff, because you got a board that's adamantly dedicated to keeping you abreast of information. And so stay thirsty, my friends, as the commercial once said, and keep an eye on stuff, because, you know, I got some help now. Brad has been wonderful, and Crystal's, like I said, the best paralegal assistant I've ever had. Her typing skills are questionable, and my review skills are worse, because it's 2025, not 2024. And I'm going to fix that, Laura, before she'll send you an updated.
Okay.
All right. Anything else? I just want to say something real quickly. Sharon, thank you for this year.
Thank you.
Laura and I, you know, when we always give the president, and Bina, that's your call next year. You can either reappoint Sharon if she's willing to do it, or take it over yourself, your call. But Sharon, you have done in all of these programs where we've done panels or these things, you've been fabulous. So I just want to personally thank you in front of everybody for your effort as the president this year.
Thank you very
I
much.
hope that got me some brownie points. No, I'm kidding.
Yes.
All right, Laura, I will talk to you later this afternoon. Linda, keep it real. We talk all the time. And
Bye,
anybody else,
everyone.
my email address is on the materials, and you're always invited to not bother me. But if you have to, do so. You know, go through Laura. Best bet, go through Laura, and then we can keep track of what's being said and what's going on. Go sell some real estate, guys.
Let's do it. Thank you, John.
Bye.
Here,
Bye,
kids.
everyone.
Goodbye.
Peace.
Bye, everybody.